proof of negligence residential ipsa loquitur. At the end, the important points related to this maxim can be summarized as follows. 1. By applying this maxim, the burden of proof is shifted from the plaintiff to the defendant. Instead of the plaintiff proving negligence, the defendant is required to prove it. The maxim is not a rule or law. It is a rule of evidence benefiting the plaintiff by not requiring him to prove negligence. 2. The maxim applies when 1. The injurious agency was under the management or control of the defendant, and 2. The accident is such as in the ordinary course of things does not happen if those who have the management use proper care. 3. The rule that it is for the plaintiff to prove negligence is in some cases of considerable hardship to the plaintiff, because it may be that the true cause of the accident lies solely within the knowledge of the defendant who caused it. The plaintiff can prove the accident, but he cannot prove how it happened so as to show its origin in the negligence of the defendant. The hardship is avoided to considerable extent by the maxim. 4. The rule of Rylands versus Fletcher is not an illustration of the principle of residential ipsa loquitur. The liability arising out of the principle can be repelled by proof that the defendant was not negligent, whereas under the Rylands rule it is not defense to say that defendant took every possible precaution to prevent the escape of the injurious thing. 5. The principle of residential ipsa loquitur has no application where the circumstances in which the accident has taken place indicate that there must have been negligence, but do not indicate as to who was negligent, or when the accident is capable of two explanations. Also, the maxim does not apply when the facts are sufficiently known. 6. Residential ipsa loquitur is a common-sense approach, not limited by technical rules, to the assessment of the effect of evidence in certain circumstances. It means that a plaintiff prima facie establishes negligence where 1. It is not possible for him to prove precisely what was the relevant act or omission which began the events leading to the accident, but 2. On the evidence as it stands, in the absence of any evidence from the defendant, it is more likely that the effective cause of accident was some act or omission of the defendant.